car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome to the attorneys. I'm Art Franklin. Thanks so much for joining us. On this edition of the attorneys, we're going to talk about some employment law. We're going to unwrap that so that you can understand all the various issues associated with that. As always, we like to remind you at the very beginning of the show that we have lawyers standing by right now at Hollis Wright. They are there to take your call. It's 1-844-LAW-TALK. That's 1-844-LAW-TALK. It is a free, confidential call. You can go ahead and get in contact with them now. Carter Clay is here. We got a special guest with us.
Yeah, we absolutely do. I mean, one of the questions that we get during the show, during the week from our own clients involve situations where they're terminated from their employment. And what we have found is a lot of people, if not the vast majority of people out there, they really don't understand what their rights and responsibilities are when it comes to being employed and the circumstances in which they can be terminated and the circumstances in which they can quit or leave their job with no repercussions. And I could think of no better person to have on the show here this evening than Kyra Fontenot. She's an outstanding attorney and practices in this area. I don't know if exclusively, but this is definitely a lot of what you do at your practice. Is that right?
That's right, Carter. I do about 90% of my work is labor and employment. The other 10% are civil rights cases where people have interactions with the police that they don't think went well.
Well, this is a common question that we get. We've got a question from a viewer right off the bat, and that is, a lot of people think that Alabama is an at-will state, and that means the employer can do anything they want. But is that true? Is there no recourse for an employee? What are those circumstances?
Yeah, so an at-will state does give employers a lot of leeway, but it isn't absolute. So if an employer does something that violates one of the laws that protects employees, at-will does not save them from being liable to their employees. So if there's a discriminatory reason for that termination, if there was something related to them complaining about overtime and they get fired because of that, if they have a workplace injury and they get fired because of that, at-will does not apply in those cases.
Okay, am I correct that the laws that we're talking about that would protect people from termination for certain discrimination type reasons, that is federal statutory law, right?
That's correct. And federal law always trumps state law. And so whenever the federal government enters the field, the state law gives way. And so even though Alabama is at will, Title VII and other laws, the Americans with Disabilities Act, the Family and Medical Leave Act, they trump the at-will statute.
What does it mean to be an employee at will or be in an employment at will type setting? Like, how do you become an employee at will, or how do you not become an employee at will?
It depends on whether you have a written contract that spells out the details of your employment that says that you have to be fired for cause. In general, most people are at-will employees. That means you can be fired for any reason or no reason at all, as long as it's not an illegal reason.
Yeah, and in my experience, what I have found is that the individuals that actually have contracts for employment, you're dealing with one or two or both situations. You're dealing with somebody who's got a sophisticated professional type background. They've got a unique quality, a unique skill set, and you may be dealing with a situation where the employer is having to invest some money, maybe equipment, machinery, things like that, so that that sophisticated person can do their job. And both sides would like some contract spelling out the terms of that type of employment situation.
That's right. Usually you're going to see that with your executives. You may see that with folks who are in sales. They may have contracts with their employment. The other place you'll see that on a broad scale is when people are in labor unions. Those contracts often overwrite at will as well.
Right. So if you've got somebody out there that has a contract of employment and they get terminated, really what you're dealing with are the four corners of the contract in terms of whether they can be terminated legally or not.
Right. If the contract says this is how you have to terminate this person, or the person can't be terminated, or it's for a specific term, the contract overrules at will.
But let me ask you this, do those discriminatory exceptions still apply?
That's a great question. You can't contract yourself out of discrimination. You can't write a contract that's against public policy, and discrimination would be one of those things. Right. And so your contract would not overrule that.
So if you had a contract and you got terminated, and there's some question as to whether or not contractually you could be terminated, but the real reason they terminated you, say, was based on race, you could have a federal lawsuit back against them for terminating you based on racial discrimination.
That's correct. If the reason why they terminated your contract was because of discrimination, you go right to the EEOC, you file a charge of discrimination, and that will start off a lawsuit for you on that basis. All
right, you brought up the EEOC, so let's talk about that just for a minute. What is the EEOC, and how does that play into your role or work?
The EEOC is probably one of the most important agencies for employees. There are a few others, the Department of Labor, but the EEOC, when it comes to discrimination, is your first stop. Anytime you have a claim of discrimination, you usually have to file a charge of discrimination, which is a written complaint, within 180 days in Alabama, so that they can investigate and then decide whether or not they want to sue on your behalf.
Okay, so they've got a right actually to come in and take over and pursue the lawsuit for you, but my understanding is the overwhelming majority of the times they send you a letter declining to pursue the claim, and then they're free to come hire somebody like you to investigate and pursue the claim for them?
That's correct. You can hire us before you go to the EEOC, and we actually recommend that. If you're going to hire us, we want to write your charge of discrimination because we know what to say in the charge to make sure that the employer understands what's going on. A lot of times you see an EEOC written charge, it might be really vague. We may put a little bit more detail in there that helps the employee get traction, but the EEOC does not have the ability to investigate every single claim. 88,000, 100,000 claims get filed every year. They investigate fully a very few of those, and they file suit very infrequently.
What other than race or racial discrimination being a protected right that could override this employee at will, what are some of the other areas of protection that would protect people?
The most important thing to understand is that everybody is in a protected class. I'm in a protected class, you're in one, Carter, everybody is in a protected class. There are several. There's being over age 40. There is having taken, asked for an accommodation because of a disability. There's national origin, religion, there's color, and there's race. There's a number of different ways that you can be protected at the EEO stage, and then other statutes that protect you even outside of the EEOC.
Yeah. Now, I know that a lot of people feel like the laws are one-sided in favor of the employer when it comes to this employee at will, because if you don't fit within that protected class, the employer could just be having a bad day and could come in and say, you know what, I'm just tired of you being here, I want you gone, and they could terminate you, right?
That's correct.
Okay.
But a lot of times people don't understand that what's happened to them is discrimination. So you should always call and check in with a lawyer, because a lot of times people call me, think they were discriminated because of their race, but it's really because they asked for FMLA. Okay. And they're not thinking about that as the trigger for what's going wrong. So even though at will is in place, if you think there's something fishy about the way you were terminated, it's always best to call a lawyer and find out, because we're asking a lot of different questions that will trigger other statutes that protect employees.
Yep. And one other point to make, I think, that is important is the employee, guess what? They can quit for no reason at all.
Right.
So you could be in an employee at will setting where you're there for a year or 2 or 3 years, and you gain a tremendous amount of knowledge, qualifications, skill sets at the benefit of being in that employment situation. And guess what? You can leave on a moment's notice and go work for a competitor, right? Or go do something else. So it's not entirely one-sided in favor of the employer, because if you don't have a contract, you can leave whenever you want.
And that's true, but if you are planning to file a discrimination lawsuit, is it best to file that lawsuit prior to leaving? You don't want to leave and then file the lawsuit?
That's a great question, Art. In fact, we often, if you feel like they've done something wrong, your best position is to complain and stay. Allow them to have to investigate that claim while you're sitting there, because a lot of times, once you begin litigation with the company, they're going to want to pay you to leave. And so it's always better, if you think that they've done something illegal, complain, file your charge with the EEOC, and come to work and smile every day.
Well, and when we come back from the break, I want to talk to Kyra about whether there are circumstances where you actually are required to stay in the employment. So we'll talk about that on the other end.
All right, Kyra Fontenot is with us as we're talking about labor and laws and discrimination in the workplace. And we want to remind you, though, that you can talk to someone right now, one of the attorneys at Hollis Wright. All you have to do is call 1-844-LAW-TALK. That's 1-844-LAW-TALK for a free confidential call to an attorney at Hollis Wright. We're going to take a break. We're going to continue this discussion on the other side of that break. Stay with us. We'll be right back.
Here's some good information from our firm to you. Hollis Wright recently launched the Law Talk podcast. With podcasts becoming so popular, this will be a simple way to provide our loyal viewers with more opportunities to access information about important legal topics and to learn more about our firm and how we can help you if the need ever arises. There are many ways to access the Law Talk podcast. You can simply scan the QR code on your screen. Also, episodes are always available on the Hollis Wright YouTube channel, as well as on Spotify, Apple Podcasts, or wherever you consume your podcasts. Just search up Hollis Wright in the Law Talk podcast. Don't wait, take advantage and listen today. Thanks for watching The Attorneys, and we know you'll enjoy the Law Talk podcast.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Addiction kills hope.
But at Bradford, it all changes here.
Experience the difference
that proven treatment can make.
Find recovery. Find community.
At Bradford.
And we welcome you back to The Attorney. So glad to have you with us. I want to remind you also to follow Hollis Wright on all the social media platforms on Facebook, Instagram, and X, formerly known as Twitter. Go ahead and get some really good content there. Like it, share it, follow it, and let other people know about it, because that's where we put a lot of good information. We've got some good information today, talking to Kyra Fontenot about what's happening in the workplace.
Yeah, and I want to talk a little bit more about this concept of staying on the job while you're being, I guess, sort of victimized by some discrimination and actually pursuing a claim, because that's very odd to me that that would happen. But I had a situation that I'm aware of involving a pharmacist that felt like he was being discriminated against based on age, wound up filing a lawsuit, but he stayed on the job for like 2 or 3 more years while he's actually pursuing this discrimination claim against the employer, which I thought was very odd. But are they required to stay on the job? Do you just advise them to? What's the law in that regard?
So there's a reason why we advise our clients to stay working there if they haven't been terminated yet. And there are really 2. Number one is when you have an employment claim where you're saying that someone has harmed you financially, you have a duty to mitigate. And so if you quit your job, it can be seen that you were not mitigating your losses, right? If you just say, well, I don't want to work there, it can cut off your damages. Let's say you were supposed to get a promotion, or they demoted you and you lost your pay. The moment you quit that job, those damages stop accruing for that lost pay. The other reason one is actually sort of tactical. We want employees who are working in the company to be there and sit there because it makes the company uncomfortable. They don't like having people with a lawsuit sitting next to people who don't have a lawsuit.
I wouldn't think so.
They don't want people to know that you could sue the employer and the employer might pay you. And so one of the things that oftentimes the employers will do for current employees is to offer them a severance to settle the case and go away. If you quit, there's no reason for the company to pay you to leave. So if you stay, that can often be helpful. The caveat to that is we don't ever want people to stay when they're unsafe. So when you're in a situation where you're being sexually harassed or racially harassed and there's a physical component or your mental health is at play, you know, we can talk about that because it can be different.
Yeah, but I guess it does make sense because the essence of your claim is if you're not discriminating against me, I otherwise would want to be here and would want to be a productive member of this employment situation. So that does make sense that they should stay there.
Yeah, ultimately, in most all these cases, reinstatement to the position that you would have had or to put you back to the place that you would have been is what you're actually seeking, one of the things that you're seeking. And so if you say, I don't want that, the other side's going to use that against you.
How about individuals that have disabilities or develop some type of disability? Is that a protected class?
Absolutely. There are two statutes that protect people who have disabilities in the workplace. One is called the Rehab Act, and the other is called the Americans with Disabilities Act. Both of those, they're very similar laws, but both of them protect people who have substantially limiting conditions. That is not the same as a person who is on Social Security disability, which a lot of people get that confused. But these are people who are living and able to work, but they need an accommodation to do so.
Okay.
It's not people who are fully unable to work.
Yeah, so Social Security disability benefits is designed for people who are totally disabled from any form of gainful employment. What you're talking about is somebody who has a disability and they're substantially limited, I guess, in their production or what they can do, but they can still work to some extent.
Correct. They are able to do the essential functions of their job. They just may need a little change to the job, or it may be that they don't need any change at all to the job, but they do have a disability. So you see people who have diseases or conditions that maybe their employer thinks stop them from doing the job, but doesn't. Those people are protected from discrimination because people think they cannot work. And also, there are people who need things to work. Maybe you need a different chair. Maybe you need some, special equipment. Those people are entitled to those accommodations, and the employer has to make reasonable accommodations to help them work.
So how does the disability discrimination manifest itself in terms of your practice? Are you typically having people that will call you while they're still employed, but they're feeling like the employer may fire them because of their disability, or are they typically coming to you after the employer terminates them because they can't perform their work because of the disability? How does that work in your practice?
It comes in both forms.
Both.
A lot of times you have someone who's very frustrated because they've asked their employer to do something simple. Can you give me a higher chair? Can I sit for 5 or 10 minutes every hour? Can I have access to the restroom more frequently? And their employer's not doing those. And they're frustrated because they want to work and their employer won't let them. And then there's the other people where their employers have decided that they're just not a useful person in their environment, and they will fire them, and then they have left the workplace altogether, and they're entitled to back pay, or they're looking for back pay because they've been terminated unfairly.
Yeah. How do you define reasonable accommodations? What does that look like?
So it really varies on the employer, but if you work for a large employer that has 50,000, 100,000 employees, and you're asking for a different keyboard, well, they can do that, right? But if you're working for a 15-person employer and you're asking to be off 4 days a week, they maybe can't accommodate. So it really depends on what you're asking for and what the company's resources are. A lot of people get messed up because they ask for something that is unreasonable and they think their employer has to give it to them, and they don't.
Yeah, and I guess is that something that if somebody's still employed and they come to see you, you help work those issues out and help define what reasonable accommodations looks like?
A lot of times we spend a lot of time talking to people like saying, hey, you're asking them to let you not work for a year. They have a right to move on and try to fill that position, right? So we're talking to people and saying, okay, is there a way that you can do this? The employers have to they have to engage in an interactive process. They can't just say, no, we can't have this. They've got to offer you. Maybe you ask for one cup that they need. They say, well, we can't give you that cup because that one's unsafe, but we can give you this one.
Yeah.
And that has to be a back and forth exchange. But be careful, because if your employer accommodation request is unreasonable, they can terminate you because you're not able to do the job.
Yeah, we're plowing a lot of ground here tonight, Art. I know we need to take a break, but when we come back, we're going to talk about protections associated with pregnancy and birth and things of that nature as well.
Yeah, I also have a couple of things that I want to talk about as well, and I guess we'll get into that in the next segment before we wrap this up today, but certainly want to remind you that you can get in contact. This is your last opportunity to get in contact with a lawyer at Hollis Wright, because we're getting into the last segment of this show. Call 1-844-LAW-TALK, 1-844-LAW-TALK. It is a free confidential call to reach someone right now. We'll be right back.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
If this place could talk, it wouldn't. It would sing and celebrate all of our stories of addiction recovery, victory, and community. This is Bradford Health Services. It all changes here.
And welcome back. You are watching The Attorneys as we're talking about what happens in the workplace and workplace discrimination. I want to talk to you, Kyra, about what employers should do if they're trying to build a case. How can they document the incidents they say that will help them build that case?
Okay. One of the biggest problems we run into is not having evidence outside of our client's word. Our client's word is evidence. It doesn't mean that their evidence isn't good, but there is nothing better than a tape or an email or some kind of text message that helps us to substantiate that what our client said happened is what happened. And tapes, videos, and audios are usually very helpful in us getting to the evidence that we need.
Careful in this state, though. This is a one-party state, right?
So, yes, Alabama is a one-party state, which means that if you are a person in a conversation, you are allowed to tape that conversation, and you don't have to tell the other person that you're taping them. But what you can't do is leave a recorder in a room and leave the room and tape people who are you're not a party to a conversation with. And so many employees can, unless they work in some of the, like maybe the defense industries where there's some security risk out there, many employees are within their legal rights to tape any conversation that they're involved in.
Yeah, Art, in terms of building our cases, personal injury, especially when we're going up against a corporation, one of the challenges that we always face is that we need access to all of the documentation and information that they have to build our case. And it goes along with what Kyra was just talking about. The employee says this is what happened, and they're adamant about it, and they're very convincing about it. But in order to build the case, to support the case, it's very helpful to have all that documentation. But a lot of times we're dependent upon getting it from the corporation, and in her situation, dependent upon actually getting it from the employer. And of course, then that raises all kinds of suspicious thoughts and paranoia and questions about whether they're actually giving you everything that they're supposed to give you. And I know Kyra's had that experience before.
The biggest place that we're going to find stuff in a case is in the emails. Yeah. We'll see them in Slack messages and emails but the company controls all that. And so if you're an employee who's a part of that conversation on an email or Slack, we see a lot of screenshots. We see a lot of people who are blind copying themselves at their personal home accounts that documenting all those things. And that's why employers will, when you're getting fired, you notice the first way you know you're getting fired is that your email shuts off. Okay? And because they know that there's documents there that are going to be difficult for them to refute, and so they don't want you to have access to that. So if you feel like there's something going wrong within your employment and you have access, legal access to it, now you can't go, tapping into the systems that you don't have access to. If you have legal access to it, if you can keep a copy of it and bring it home, that's probably going to be better than depending on waiting for a subpoena. I can't subpoena people before the lawsuit begins.
That's right.
So I really, if you can come to my office with the details right in front of me on paper, that's going to help you out a lot.
In the remainder of our time, I want to talk about pregnancy and issues or protections related to women that are pregnant or having a child. Is that a protected class?
Absolutely. And in fact, Congress just a few years ago actually increased the protections for women who or people who can have children in the workplace and made them almost like folks who have a disability, in fact, in that they are able to get accommodations to allow them to continue to work while they're pregnant, and for some conditions that are related to pregnancy, even before or after their pregnancy.
So is that analysis the same as it is with disabilities that we already talked about in terms of these reasonable accommodations and trying to figure out what is or is not reasonable?
So there is a certain correlation to it, but actually the way the regulations are written on pregnancy is actually more lenient towards the employee than disability accommodations. And so the way it's written right now, it says if the company, if you ask for it as a pregnant person in the workplace, they're going to have to prove pretty much that they could not give it to you. All
right, I'm going to put you on the spot here. And how I'm going to put you on the spot is remote work considered a reasonable accommodation? And I hesitate to ask that question in terms of whether our employees are actually watching the show. But at any rate, I'm going to ask it anyways.
Absolutely. Remote work is probably one of the best reasonable accommodations. There are very few jobs, coming out of the pandemic, there are very few jobs that are going to be able to say that job has to be in person. There are some jobs that need to be in person, but the vast majority of your desk jobs, they're going to have a hard time after everybody went home for a year and worked from home saying that it's an essential function of your job to be in the office.
But they got to have a disability.
Correct.
Right. So employees that are out there just saying, I want to remote work and y'all got to accommodate me, it only applies if you can show you've got a disability under the Act as well.
That's right. And so for all these companies, recently Amazon, AT&T, a lot of these companies are requiring people to come back into the office. Only those folks who have an accommodation that they need to make because of disability or possibly pregnancy are going to be looking at the ability to avoid going back to work.
Yeah, just a little bit of time left. Breastfeeding, interesting topic here. Do they have to provide some accommodations in that regard?
Absolutely. Women are required to have a clean, safe place to express breast milk in the workplace and breaks to do it at intervals throughout the day. And that place cannot be a restroom. So they need a clean, private space that allows them the opportunity to create the nourishment for their child.
I thought the restroom was a nice reference there. They headed that one off pretty quickly.
Cannot do it there.
Yeah. Not the restroom.
Kyra Fontenot, thank you so much for being with us.
Thank you.
We really do appreciate it. And we thank you for being with us as well. A lot of great information here. We hope you enjoyed the show. If you did, go ahead, go to social media, like it, share it, and let other people know about all the great things happening with Hollis Wright. Thank you. We'll see you on the next edition of The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.